Welcome to the Nurture Effect podcast, hosted by Dr. Anthony Biglan, a pioneer in prevention science, best known for his work on nurturing environments, community-level behavior change, and his books, The Nurture Effect and Rebooting Capitalism. Today's guest is Stuart Ford, a scholar of international criminal law, constitutional law, and human rights at the University of Illinois Chicago School of Law. Before entering academia, he served as an assistant prosecutor at the Khmer Rouge Tribunal in Cambodia and has advised organizations including the International Criminal Court and the United Nations. His work focuses on international justice, constitutional interpretation, and democratic institutions.
You're at the University of Illinois in Chicago Law School, is that correct?
Yes. So I'm a professor at the University of Illinois Chicago. I do have to say, however, that I'm speaking here in my personal capacity and not on behalf of either the University of Illinois Chicago or the law school.
Right.
These are my personal opinions based on the research I've conducted over the last, 5 or 6 years.
How did you get interested in the preamble?
So I've always thought the language of the preamble was, beautiful. And that's, in fact, if you think about preamble, mostly people think about it as being a very sort of beautiful introduction. But I hadn't really focused on the legal effect of it. And then I started doing a little research, and you quickly come across, there's a famous US Supreme Court case, well, famous amongst lawyers anyway, called Jacobson, in which the Supreme Court essentially says that the preamble doesn't have any effect. That decision was really decided in 1905. And basically since that period, most US courts have basically ignored the preamble. Mm-hmm. And I was wondering, it contains a number of principles which seem really important today, like the general welfare, the idea about forming a more perfect union. These are concepts which seem like they should be relevant today. And I was sort of interested in, well, what do they mean and do they have any relevance today? So I started looking into that. And I started with the general welfare because that seemed like the phrase within the preamble that seemed to have the most relevance to some of the sort of problems we're having today. In fact, if you think about I was really influenced by Garrett Hardin's article, The Tragedy of the Commons, before law school, and the idea that there are some problems that are really hard to solve if everybody acts only for themselves. Mm-hmm. And I think the framers of the Constitution understood that. I mean, obviously they didn't have the theory of the tragedy of the commons, but I mean, the general welfare expresses this idea that people have to put aside their individual interests in order to pursue the interests that are best for society as a whole, at least sometimes. Maybe not always, but at least sometimes. And that's particularly true for people who govern, like politicians. The people who govern for us have to be particularly careful of that their actions benefit the general welfare, not just the individual welfare of particular people. And that concept, I think, has relevance today. And I wanted to see whether it could have any legal relevance beyond sort of the philosophical relevance. Could that be something that could have legal relevance today?
And I come back to the notion that it took 40 or 50 years for the Supreme Court and the Federalist Society to move in the direction that it's taken. And I think your paper is maybe a step towards reform that's needed.
Yeah, maybe. I mean, the sort of the liberal progressive lawyers and philosophers have tried to create something like the Federalist Society for Liberal Progressive Issues. That's the American Constitution Society. Right. And they've started to try and do something like what the Federalist Society did in the 80s and 90s, which is identify lawyers who could become judges, try and promote them, get them put on the bench, etc., and try and develop a sort of legal philosophy of liberalism that could be a counterbalance to the sort of originalist philosophy that the Federalist Society pushed. Now, they haven't been horribly successful yet, but obviously they haven't been at it nearly as long as the Federalist Society has either. So too early to know whether it'll have an effect or not.
What you're focused on in the preamble, I think, is as you suggest, really important to this movement. And I see it as a movement not just of lawyers, but of getting many organizations involved in it. What do you think about that?
Yeah, I mean, I'm focused on the legal aspects of things, being a lawyer and a law professor myself. I do think that there are places where a concern for the general welfare, particularly where there are sort of significant externalities to things that people do, and those externalities aren't accounted for in this
Right.
normal way we do business, then you obviously have significant risk of downsides. Like climate change is the thing I think is obvious, right?
Yeah.
Climate change is very hard for individuals to mitigate climate change. We need to all work together to mitigate climate change. We need the government to work for the general welfare. So I think that I see that as being the place where a concern for the general welfare is both historically accurate because it tracks how the Constitution was understood at its origins, but also would be really helpful in helping us resolve what is arguably the sort of greatest crisis facing us over the course of the next century. So I definitely think, I hope that this concern for the general welfare isn't simply an academic concern, that it does have real world consequences and could help us deal with problems that we don't seem to be really grappling with very effectively right now.
Well, and that's, I mean, you're really describing the kinds of things that we're trying to do at Values to Action to really promote the movement that's needed to reform society, where the fundamental measure is the degree to which people are thriving and the degree to which corporations are not acting in ways that are harmful to the society. And so you said in 1905 that that was the key thing, and I read that, and it's never come up since then.
Well, not to the Supreme Court, right? The Supreme Court has never since then taken a position on the role of the Constitution, the role of preamble in understanding the Constitution. It's been raised occasionally at the lower courts before, particularly before trial courts. But most trial courts that have had this question raised have simply said, no, the preamble doesn't do anything, see Jacobson, right? So the result is that at least since 1905, the preamble has largely been ignored or forgotten by the courts. And there are lots of scholars that have recognized this fact. That's not like novel. And so one of the things I've been trying to do is ask, is that the right answer? What is that all the preamble was meant to be? Did Jacobson make a mistake? I mean, I'll give away my answer here. Yes, Jacobson was a mistake. It was a pretty egregious mistake in some ways. There's this principle that we sometimes hear lawyers say where like dicta makes for bad law. Like, and I think that's what's going on in Jacobson. So Jacobson is the discussion of the preamble in Jacobson is what lawyers would call dicta obiter passum, or words that are like said, but they're not really directly related to the decision. And so the discussion of the preamble in Jacobson is not part of the decision, right? The decision isn't about the preamble at all. There's this one throwaway paragraph at the very beginning of the decision where Justice Harlan says in passing, oh, and by the way, the preamble doesn't like have any effect. And there's a citation to one source, but interesting, the source he cites doesn't say what he says. The source says the preamble is crucial to understanding how the Constitution should be interpreted. So he cites one source, which he miscites. He ignores a whole bunch of earlier Supreme Court decisions which had treated the preamble as relevant to understanding the Constitution. And that like one throwaway paragraph has come to dominate how we understand the preamble today, in direct contradiction to both how it was understood at the founding, but also in normally how you would understand preambles generally, right? And if you think about it in a general sense, preambles are used in lots of contexts, in contracts, in regular legislation. Preambles state the goals of the document. And if you have questions about how to interpret the document, then you look at the preamble and you usually interpret the document in line with the goals articulated in the preamble. That's how preambles are generally used. And it's sort of odd that the preamble of the US Constitution is just treated as if it doesn't matter. Like that is a really weird way to treat a preamble. It's not how we treat other kinds of preambles. So why do we do that to the Constitution?
So you alluded early on in this discussion to how these things have evolved. It seems to me that there's not a set of written rules for how courts should make decisions. It's
no. There are different theories, different like sort of theories of constitutional interpretation, and people are, and they all have strengths and weaknesses. Some, like originalism is a theory of constitutional interpretation in which the goal is to give the Constitution as much as possible the meaning that it had at the founding, or whenever the particular provision was adopted. So for like, for example, the 13th, 14th, 15th Amendments, you'd be concerned with what did people understood them to mean in 1868. Whereas for the original Constitution, you're asking what do people think they meant in 1787, 1788, right? And the idea is that in theory, at least, this reduces the ability of the judge to impose their own values on the Constitution because you're limited to what the founders would have understood the Constitution to mean.
Am I correct that the Dobbs decision was predicated on the notion that nobody was talking about abortion when the
Well, that goes to one of the downsides of originalism, right? So the idea is the benefit of originalism is arguably that it limits us to the original meaning, limits the ability of judges to sort of make up things as they go. This is one of the concerns that conservatives have had about liberal judges for decades, right? So the downside, and there are significant downsides, and a couple of them are, one, of course, the Constitution didn't have a single meaning. Like, it's not like everybody agreed that the Constitution meant only one thing in 1787. In fact, there were two major camps at the time. There were the Federalists and the Anti-Federalists, with the Federalists wanting the adoption of the Constitution and the Anti-Federalists opposing the adoption of the Constitution. And they often disagreed vehemently about what the Constitution meant. So one problem that originalism has to deal with is, what was the original meaning when people couldn't agree? That's a serious problem. And lots of people have criticized originalists for essentially treating what is a messy sort of dialogue between different groups and like ignoring that and sort of collapsing it down to a single correct answer, which is chosen sort of post hoc, right? And that's a concern. And one of the other big concerns about originalism is that obviously it doesn't adapt well to changes, right? The world we live in today in the 21st century is in some ways very, very different from the world of the 18th century. And, rigidly sticking to things that 18th century people would have expected in a 21st century world can lead to sort of absurd or, far from perfect outcome. And so there are other theories of constitutional interpretation that take other approaches that attempt to mitigate those concerns, but they have, weaknesses of their own. It's not like there's one perfect method of constitutional interpretation. There are different theories and they all have different strengths and weaknesses.
So as you're talking about this, I'm thinking, there's a sort of evolution of practices, not just in the law, but in society generally. And my background is in public health. And I start with the basics of public health is the incidence and prevalence of illness and the incidence, in particular, premature death. And we've written a lot of things about the way in which the current situation is harmful, accounting for the health disparities, not simply in terms of lack of access to healthcare, but to poverty, economic inequality. And I find myself thinking that one way that I find myself thinking about it is that we have accurate measures of the well-being of the population. And in fact, in this country, we have the highest level of child poverty, we have the highest level of economic inequality, and we have ample evidence that child abuse and neglect is significantly more likely in high levels of poverty. So what I want is for the courts, for our judicial system to be functioning to address the problems that we have. What's your reaction to that? What do you?
And well, my first thought is I'd rather that the legislative branch was more responsive to the concerns, right? Like,
yes,
the judiciary is like a backstop. It's not supposed to be the main protector of rights. Ideally, the legislature should be legislating in ways that benefit all of us. So first and foremost, Congress has been dysfunctional for, I don't know, the better part of the last decade, right? They
yes.
are unable to pass legislation about anything that seems to really matter. And that's a problem, right? We're stuck.
Right.
We're unable to address huge problems because we can't get enough votes for any sort of solution to anything, it seems sometimes. Do the courts play a role? Yes, absolutely. But they play a secondary role, right? I don't think the first solution would be fixing Congress, however you go about doing that, right?
Right.
Producing a Congress that is more responsive to the needs of the people. And that ties into other things you talked about, like the role of special interests and the role of money that plays in our political landscape today has been, I think, wholly detrimental. But
Well, it's owned by great wealth.
mm,
Citizens United is one example of the corruption of the
yeah, and that's a weird
electoral
one, right?
system.
Citizens United, like it's allegedly, I mean, it's a First Amendment case, right? It's about the First Amendment. But would the founders have thought corporations were people? Would they have
Well,
thought that corporations had the right to contribute unlimited money to politicians? I sincerely believe the answers to both those questions is no.
well, I've looked at the history of corporations, and they hardly existed in 1800. So, I mean, you're right about the need for the Congress to do this, but the court decisions are key to the
Yes.
fact that we're not getting what. I mean, my book Rebooting Capitalism I published several years ago. I have a long list of policies where the majority of Americans are highly in favor of those policies, and in years they haven't been adopted. It's basically because wealthy corporate interests control the government. What are your thoughts about that?
I agree. I wonder to what extent, like, can the preamble help us solve that problem? I mean, maybe. I do think that one thing that is probably true is that the way in which rights were conceived in the 18th century is not as absolute as the way they've been interpreted in recent decades by the Supreme Court. And there was, I think, and I've my goal is to write about this like more fully at some point. There was a sense that the general welfare and individual rights were in tension, and that 18th century, even 18th century Americans, which would say that there were rights to, for example, they were very concerned with rights to a jury, the right to freedom of the press, freedom of religion. Those were very important concerns. But at the same time, I don't think they would have viewed them in quite the absolutist way that we do today. And they would have seen them rights as being a trade-off between the individual's rights and the welfare of society as a whole. And it's possible, it seems to me, that you could think about a way of thinking about the Bill of Rights where a concern for the welfare of society is also a factor in how we understand rights. And that might play out in a case like the First Amendment case about the Citizens United, where rather than just saying, they have absolute right to free speech, you'd say that there is a right to free speech, but it has to be consistent with the needs of society, and that allows some sort of governmental regulation, and that might then have led the court to not overturn the limitations on corporate, giving to political campaigns. So could a concern for the general welfare have led to a different outcome there? It's possible. I mean, obviously, it's in hindsight is always 2020. Like, we don't know what a different theory would have led the Supreme Court to, but I think it's at least conceptually possible.
So I wanted to ask you about motivated reasoning.
Yep.
Jonathan Haidt is a psychologist who's written about that. The notion is that humans naturally, if you ask them with their opinion, they'll give you opinion and they'll put words but it's actually the emotional thing that drives what we say, as opposed to the words so I'll give you a reason why we should do X, Y, or Z. And it's my words that'll, are definitive and stuff. Well, no, I actually wanted that. And now I'm going to come up with words that would justify it. And
Yeah.
it seems to me, and I come back to Jane Mayer's documentation of the funding that went into the promotion of free market economics as something that evolved. They poured money into not just the Federalist Society, but all kinds of things. They trained lawyers, they trained economists, and they promoted the success of those economists and lawyers to promote these things because the policies were in the interest of the wealthy people who wanted to promote free market economics and convince you that if I'm making a lot of money, I must be doing something right. That is basically Milton Friedman's view of it. Thoughts about any of that?
I'm going to try and tie it back to sort of the legal side of things. So
Yep.
One of the critiques of originalism has been that we're not quite sure sometimes whether judges are attempting to figure out the original meaning of the Constitution, or they're cherry picking particular documents that support the meaning they want to get to. And I know that one of the allegedly the strengths of originalism was that it was supposed to remove judicial bias from decision making, but there's been considerable criticism of a number of decisions that Scalia has made over the years using originalism, where commentators, historians, other legal scholars have said Scalia cherry-picked the particular snippets of decisions or language that would support the outcome he wanted to reach. That he's not really engaging in history as historians understand it. He's trying to justify the outcome he wanted to reach. And that would be like an example of motivated reasoning, right? And I don't think judges are immune to motivated reasoning just because they're originalists. You just go about it in a different way. Whereas they would say that progressive judges engage in motivated reasoning in the sense that they do very much the same thing. They pick the outcome they want, and then they try to find some justification to support that outcome. But originalists can do that too.
Well, that framework might be the health of the population.
I didn't know
the general welfare.
This is the area I've written in. So I spent a lot of time reading thousands of 18th century newspaper articles.
I was impressed.
Including the words general welfare to try and understand what those terms meant. And I can't promise that I have no prior biases, but as best I can tell from looking at thousands of documents, the concept of the general welfare did have a pretty well understood and broadly accepted meaning in 18th century America. And that when that term, the general welfare, is adopted in the Constitution, it would have been understood to mean something specific. It's not like those words, it's not the first time those words ever appeared in print. Those words had been used going back to the 15th century in England and to the 17th century in the United States. And by the 18th century, most Americans would have had some understanding of what that term meant.
What was that understanding?
It appears to have been generally accepted that the general welfare is either the most important or one of the two most important goals of every government. We see that in a number of sources. It's often paired with the common defense as being either the most or one of the two most important goals of any government. So its inclusion in the preamble is not surprising. Everybody agreed that promoting the general welfare was, in fact, one of the main purposes of government. There's an idea that governing officials in particular have a duty to promote the general welfare. We see that going back throughout the colonial period in the United States, with both colonial governors who were appointed by the king or from Britain, but also the representatives that were appointed and elected in the United States to advise these governors. All of them are saying that the purpose of government is to promote the general welfare, that politicians, government officials have a particular duty to promote the general welfare and to set aside their own personal interests in service of the general welfare. So that's very common throughout the 18th century.
But you haven't defined general welfare.
Yeah, so what is the general welfare? It's an understanding that the goal of government is to promote the health, happiness, and prosperity of the people. There's not like everybody agrees about every aspect of it, but those three concepts are critical to the concept of general welfare. It's health, happiness, prosperity,
and happiness.
Yeah. And so the government has a duty to promote things that make people healthy, happy, and prosperous.
Have you written something that specifically says those three things?
So English dictionaries begin around the 17th century, and there are obviously 18th century English dictionaries. Most people are probably most familiar with Samuel Johnson's Dictionary of the English Language. Well, none of them contain exactly the phrase general welfare, but the term welfare appears in most of them. You get some variation of physical health and well-being, happiness, prosperity, success. Those things are considered to be welfare.
And that's in the paper that I've read.
Yeah, the original. Yeah. So I wrote a paper called "The Original Meaning of the Duty to Promote the General Welfare," which can be found in the 59th volume of the Willamette Law Review at page 263. Yeah, so I mean, I look at what dictionaries in the 17th and 18th centuries say about this. What did English writers in the 16th and 17th centuries say about it? What did 18th century American writers say about it? Was it discussed during the debates over the ratification of the Constitution? And what I get out of that is, if you look at all that together, there's a generally accepted understanding that government has a duty to promote the health, happiness, and prosperity of the people.
From an originalist point of view, I mean, you've won the argument.
I mean, people are going to disagree, right? It's not like this is going to convince everybody, but I think it's
Well,
interesting that if you are committed to giving the Constitution its original meaning, then oddly that makes you somebody who has to consider the objects and purposes of the document when interpreting it, which is, I think, there's often been a sort of divide between originalists who say that we don't use the objects and purposes to interpret the document, and progressives who often say we should use the objects and purposes. But I think originalists should also be using the objects and purposes of the document as articulated in the preamble to understand the meaning of the other parts of the Constitution.
using what?
Yeah, using the words and phrases in the
Uh-huh.
preamble, those are the objects and purposes, right? That's the purpose of the preamble. It states clearly the objects and purposes of the Constitution. And so, and it was understood that way by 18th century Americans, which means I think if you're an originalist and you want to know what the Constitution means, you should interpret it in light of the objects and purposes described in the preamble, which is what we traditionally think of as being the liberal approach to constitutional interpretation. But I think it's also the original approach as well.
So, if 10 years from now, there's a significant movement in society toward the views that we're talking about, how would that come about?
We'd have to be a less divided society, right? Well, like it's very hard to accomplish anything when society is as divided as it is today. And by most measures, it's more divided now than it has been since like the 1920s or 1930s. And there's an interesting link there with inequality too, right? That inequality appears to be driving the divisions in our society.
Yes.
I think there's pretty clear evidence that inequality undermines democracy.
Well, we're certainly not in a tranquil period in this country. And I think I did some work with AI this morning on the degree to which you could identify court cases that are relevant to our lack of tranquility. And of course, the one that comes to mind is Trump versus the United States. I think is the citation for it.
Is that the one that grants him immunity?
Yes, yes.
Yeah, I mean that's like a weird one too, because like, is that really the original meaning of the Constitution there? That looks like, from my perspective, that looks like an example of motivated reasoning.
Yes, yes. Well, and in fact, if you look at the history with Roberts, he was an advocate of much stronger control by the president, even when he just got started I think he was in the Reagan administration. So imagine we join forces here, not just you and me, but the legal profession, the public health profession, and make a case for this. But then the question is, how do you create a social movement that gets the support to do these things? You know, the first half of the 20th century was a social movement. The progressive movement that started in 1890 and went through, you know, the New Deal, and that was a social movement. And it takes getting a lot of people involved. There are a lot of people currently involved with the push against ICE. And that's, you know, and what Indivisible is doing, you know, there's some hope. And what I'm trying to do is just find ways to promote those things. And, you know, what I can do is articulate the way in which profit maximization is driving all kinds of activities that are harmful to people. You know, but then I start thinking about the courts, not just separately from everything, but, you know, how do we influence this?
Yeah, I mean, I think the American Constitution Society has probably the right idea, right? They're trying to create a mirror to the Federalist Society to create a pipeline for promoting young lawyers who would, you know, advocate for liberal progressive values and getting them into the federal judiciary, and then maybe eventually to the Supreme Court. But mainly, I mean, everybody focuses on the Supreme Court, but there are only 9 of them, and there are literally hundreds of federal judges. And they make all decisions all the time that matter for everybody. So
yes,
just putting judges like on federal district courts is really important too, if you want to influence the system. That's something that the Federal Society recognized a long time ago. And I think the American Constitution Society is trying to do something like that today.
And what kind of money do they have to do it? Because
much less than the Federal Society. I think I saw
there you go.
Recently that their budget was significantly less than the Federal Society's budget.
Right. Well, again, Jane Mayer's book Dark Money documents all of this. They poured money. And they understood that the Powell memo. Powell was put on the Supreme Court after this. He was a prominent lawyer that Nixon put on the Supreme Court. But his neighbor was the head of the Chamber of Commerce Education Committee. And so he wrote this memo about 1970 to his neighbor, and it was basically describing how business was. There were something like several hundred bombings of businesses in the United States in 1970, and the business was reviled, and Powell very nicely described what was happening, and he said that it's essential that business has to stop futzing around with this and needs to get organized and make the case for these things. And that has generally been seen as the thing that started the Koch brothers and the other very wealthy people to pour money into the promotion of free market economics. The University of Chicago got good funding and support for it. And then they realized that the universities were in the control of the left wing, but they started to have programs that would move this stuff. And my book Rebooting Capitalism, documents this, but I drew a lot of it from Jane Mayer. What I'm trying to do is just get a following.
I don't know if you're familiar with the Planck principle. Have you heard of that one?
The what?
The Planck principle is associated with the physicist Max Planck. And he was talking about how physics progresses over time. He said this is from Scientific Autobiography, 1950. An important scientific innovation rarely makes its way by gradually winning over and converting its opponents. It rarely happens that Saul becomes Paul. What does happen is that its opponents gradually die out. The growing generation is familiarized with the ideas from the beginning, another instance of the fact that the future lies with the youth. Are we going to convince, most people who are currently conservative to change their mind? No. But the next generation, maybe we can convince them, and then 30 years from now, they will be the ones making the decision.
And what worries me is that they do not understand the root cause of our problems is profit maximization. Milton Friedman published a paper in the New York Times in 1970, around the time that Powell was talking about this, that said, the only job of corporations should be to make money. And that has been the ruling, the theory. There was this one guy who bought a pharmaceutical company.
Yeah, I remember that one.
And he raised the price of a drug like $700 instead of $7, something like that. And he was just outraged that anyone would say that there's anything wrong with that, because he knew that he was making money. And if he was making money, he must be doing something right.
Yeah, but he's not making money by innovating a product. He's making money by taking advantage of the fact that the way in which we regulate drugs grants a functional monopoly to particular industry. So that's just rent seeking. That's not innovation.
Right.
Like I don't have a problem with innovation, but like when corporate profits come largely from rent seeking, that's a problem, I think.
Well, we got monopolies everywhere. I mean, Lena Khan had 2 years to try and 2 or 3 years to try and reinstate the law regarding trusts, but they got rid of her pretty quick. And in fact, when Kamala Harris was running for office, a relative was working on it, and he was definitely going to get rid of Lena Khan. They didn't want that kind of regulation.
I think this is a generational issue. I'm going to wait 30 years.
I just want to give me some measures that are moving in the right direction, and I'll be a happy man. But what I'm doing, Values to Action, is starting an effort called a Nurturing Nation. And we are articulating the ways in which people are being harmed and the things that are needed to prevent those things. And, and one of the things that worries me is that, people can be really angry and they're going to vote this person out and that person out. But as long as it's still okay for corporations to simply maximize their profits without regard to the impact on people, it's like weeds. You cut the leaves off the weed, you don't get to the roots, it's going to grow back.
One of the issues papers I want to write in the future is going to be about, like, how do you actually litigate this issue, right? So I do all this. I've basically done a lot of preparatory work about how the preamble should be, I think, interpreted if you're going to be true to what it really meant in the 18th century. But then how do you get that before a court? How do you pick the right case? What arguments do you make to the court to convince them to adopt this reasoning? So that's that's one of the things I'm going to write about next, is sort of how do you actually take this research and use it in litigation to try and get meaningful outcomes.
I like that. I like that a lot. Getting the right court case, that could be valuable. By the way, I was president of the ACLU of Oregon for a while, so I've been hanging out with lawyers for a long time. So
yeah, and sort of those sorts of advocacy organizations are probably best placed to find the right sort of case and to have the legal capacity to engage in the kind of litigation you would need to raise these issues, I think.
Well, wouldn't the evidence on the harm to the population be dispositive in many of these cases?
Dispositive? No, probably not. I mean, you're working an uphill battle, right? The Supreme Court has said that the preamble doesn't matter. It doesn't say it quite in those words, but that's the way it's been interpreted. And so you are going to first have to convince a court not to follow the Supreme Court. And that's going to be an uphill battle. And you got to have a really good explanation for why it is the court should not be following Jacobson versus Massachusetts before you can even get to the question of what does the general welfare mean. Well, so there's some really significant obstacles that a litigant would have to get over.
So
I mean, there are organizations that engage in strategic litigation all the time, like ACLU, the NAACP. There are others so organizations do engage in that sort of long-term strategic litigation. I think the trick is to find an organization that cares enough about this issue to invest the time and effort in that sort of long-term strategic litigation.
Well, it would be useful to come up with an example of what that case might be about.
Well, I mean, right now, the Trump administration just tried to overturn the EPA's endangerment on CO2, right?
Yes. Well, one of
Could you raise the general welfare there? Yes. Do you have to? No. There are lots of other arguments you can make. So you'd have to convince some organization that it's worth raising the general welfare as one of the arguments they're going to advance when challenging this executive order or whatever it is, or ruling.
I'd be happy to write something on that. One of the conservative justices in one of the cases within the last year asked some questions that indicated that he thought that climate change was a problem. And I can't remember who it was, but I thought, that's encouraging. What they're doing with that is just appalling.
And I think that an argument about the general welfare could be made.
Yes.
But lawyers always have to make choices about which arguments you're going to make. And you don't want to make arguments you're going to lose, right? You want to find arguments that are winning arguments. So you'd have to convince somebody that this is an argument that's worth making and that you have a reasonable chance of winning at. But if you can do that, then I think it might be possible to find somebody willing to take that litigation and run with it.
And is there a benefit to winning some of those cases, even if you know that it's going to be overturned by the Supreme Court?
I mean, you start with district courts, right? If you can't convince a district court judge, you can't even get to the Supreme Court. So you start with the district courts,
right?
And then you work on the appellate courts, and hopefully you can convince a couple of them. And then if you can convince a couple of them, then the Supreme Court might take it, and you might lose the first time, but you might go back again. This is a really long-term project. You're talking about decades of work,
right? But
it can be done, and the Federalist Society has demonstrated that it can be done.
This is exciting. What you're doing, I think, is wonderful, and I think that if you cross what you're doing with a public health perspective, then I think there might be some ways to move forward on it.
Thanks for tuning in to the Nurture Effect podcast, a Values to Action initiative. Make sure you subscribe so you never miss an episode. Values to Action is a community of scientists, clinicians, and concerned citizens that seeks to leverage behavioral science, affect change, and make the world a better place for everyone. Join the movement at valuestoaction.org.